Hello, and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk about the wardrobe malfunction or the dress code violation, where a Liberal MP, William Amos, was caught naked on a House of Commons Zoom meeting. So, still image from that has been provided to the press, and it's perfectly timed so that his cell phone is blocking the key bits of his anatomy. And but for that, everything would have been on display. So it's fairly clear that the people in that meeting got a full view of the full package. Pardon the pun. So this raises some potential interesting things to talk about. In particular, the distribution of intimate images section of the criminal code, which has a whole bunch of sort of unsettled questions that are potentially fascinating. And this is a good opportunity to talk about them. Before we get there, we should get through some of the sort of details of this one. So what Mr. Amos says happened is that there was this meeting going on and he went for a jog and then came back and changed into his work clothes. That seems like an interesting timeline to me because, this meeting is going on. So clearly you got to log into the meeting and get it fired up. And then you go for a jog in the middle of a work meeting. And then you come back and change in the living room. And I guess it's possible. So we'll go through the hypothetical scenario of what if this is intentional. And this is a hypothetical scenario just to consider legal issues. But the story is kind of weird. I don't know what happened here, but it's a weird story to me. That said, this is probably the first time that a Liberal MP was not engaged in a cover-up. So I guess we'll be happy about that aspect. Anyway, the other another potentially important note here is that this was a closed Zoom meeting. It wasn't open to the public. So this video was not going to be distributed to anyone who wasn't a part of it. But there was quite a few people involved. It was MPs and staffers. So we should assume that's a fair number of people. That all said, let's go and have a look at the intimate images section. So these are provisions that are commonly sort of referred to as bans on revenge porn, because that's where it usually comes up. And I've probably gotten YouTube mad at me by saying that. So let's have a look at what the law actually forbids here. So publication, etc., of an intimate image without consent. So let's skip over first the nature of the offense and jump to the second part, which is the definition of intimate image, because that's going to be most interesting here. So in this section, intimate image means a visual recording of a person made by any means, including a photographic, film, or video recording. A, in which the person is nude, is exposing his or her genital organs or anal region or her breasts, or is engaged in explicit sexual activity. B, in respect of which, at the time of the recording, there were circumstances that gave rise to a reasonable expectation of privacy. And C, in respect of which the person depicted retains a reasonable expectation of privacy at the time the offense is committed. So there's a whole bunch here, and this is necessary for the intimate images element. A few things I'll cover. Video recording has been held in case law, and there's not a whole lot of case law on these sections. They're fairly new sections. They're from 2014, which in the legal sphere is very new. So there's not a whole lot of case law, but video recording has been held to include simultaneous things. In particular, a FaceTime video showing somebody who was in the nude who was not wanting to be filmed in that scenario was held to be a video recording and to qualify under this section. So video recording doesn't have to necessarily be something that is permanent. However, when we're talking about a screenshot from a video, at that point, it's fairly clear that this is a visual recording of a person. The next bit is in which the person is nude, is exposing his or her genital organs or anal region or etc., etc., etc. This has been held to be disjunctive. So each of these sort of sections is separate. So just being nude is enough. And this individual is nude. So notwithstanding the fact that there is a cell phone covering the key moments, it would seem that 2A is, we can check that box here. B, in respect of which, at the time of the recording, there were circumstances that gave rise to a reasonable expectation of privacy. Now, this is going to be an interesting question on this one if it were to go to a trial, which I don't expect. But if it were to go to a trial, this individual is in his room, and he says that he's not aware that he's being recorded. Now, it's him doing the recording, but he says it's accidental. So has he lost a reasonable expectation of privacy by that? And whenever we look at this section, I think it's really important that we don't just imagine the scenario of this Liberal MP, but let's also consider the scenario of what if it was one of his female colleagues or somebody else. Maybe not him, but maybe his wife has a shower and walks through the background. Do these things destroy a reasonable expectation of privacy? I don't know. This one is a real big question. It's hard to say. The other thing, to consider here is let's consider the hypothetical. And again, there's no evidence of this. So this is just purely a hypothetical to consider the scenario. But let's say he did it on purpose. Let's say, or not him specifically, but let's say somebody did this on purpose, where they were intentionally trying to either shock their colleagues or titillate them or in some way, engage them in that fashion. Would they still maintain a reasonable expectation of privacy? Does it matter how many people are in this closed Zoom call? If it's 5 people versus 50 people versus 500 people, what if it's everybody on the planet except Joe? So everybody except one person. Can you maintain a reasonable expectation of privacy with respect to that last person? I couldn't find any case law on this. It's really kind of an interesting question. But it is notable that this was a closed recording. This was not something that was intended to be open to the public. And my limited understanding, and I could very well be wrong on this because I didn't have time to dig into the research on this, I did find that the House of Commons forbids cameras from the public. But my understanding is that this particular video was not to be recorded and not to be shared. So does that matter? It's really hard to say. And in respect of which the person depicted retains a reasonable expectation of privacy at the time the offense is committed. Now here we're talking about sharing happening very contemporaneously to the recording, basically the same day. So there's not a big gap here, but the reason why this particular section comes in is that you can envision a scenario where at the time of the recording, there might have been circumstances that gave rise to a reasonable expectation of privacy, but in between, that's gone away. So let's say a couple records some private photographs, and at the time, there's no intention for distribution. And they break up, and each of them maintains copies of those photos. Now, if he goes and shares those photos, or if she goes, if the photos include him, and shares those photos without the consent of the other, then that would be an offense. But let us consider a scenario where, say, she goes and shares the pictures publicly. She sets up a web page or the like. And after that happens, he goes and shares the pictures as well. In that case, we'd see that the reasonable expectation of privacy has probably changed from the time where the offense or where the recording happened to the time when the offense or the alleged offense of sharing them happens. So that's why that provision is there, because it's theoretically possible for those to change. So is this an intimate image? I don't necessarily know. This is a really interesting thing, but it's arguable, certainly. I would not be offended. This wouldn't offend my sense of justice if a Crown prosecutor said, yes, this could go to a trial. I don't think that anybody will. I don't think anyone's going to prosecute this, but this is arguable. It's really a question for some debate. Now let's go back up to the actual offense itself. So everyone who knowingly publishes, distributes, transmits, sells, makes available, or advertises an intimate image of a person, knowing that the person depicted in the image did not give their consent to that conduct, or being reckless as to whether that person gave their consent to that conduct, is guilty of either an indictable offense with a term of not more than 5 years or an offense punishable on summary conviction. So publishes, distributes, transmits, sells, makes available, or advertises. That's a big, broad set of categories. In this case, would we say that it's been met? Yes, transmits is enough. Sending it to one person is enough. But if you put it and send it to lots of people, that's also enough. If you make it available, even if no one actually downloads it, that's enough. So if you put it on a sharing site and nobody actually goes and downloads it, that's still making it available. Again, also the advertising. If you say, hey, I've got pictures of my ex and, I will sell them to you for $50 or whatever, that would be an offense even if you never actually provide the pictures. So that's kind of its own, there's a broad set of how you can trip that part up here. And it appears that these images were transmitted. So I think we can check that box as well. Knowing that the person depicted in the image did not give their consent to that conduct, or being reckless as to whether they gave their consent. I think we can check this box as well. I'm pretty sure that this MP, William Amos, did not want this to be shared with the media. I can't see a scenario where I could imagine that he was like, yeah, no, send this off to the National Post. I really want to make sure everyone sees this picture. I can't see an argument for saying that consent existed here, or that somebody could not have been reckless in believing that that there was no consent. So it seems to me that this is another box checked. So here we've got a whole lot of issues, and the main issue is going to be the reasonable expectation of privacy one. Does that exist in this scenario? And again, I can't say. The other thing that comes up is there's a defense, which is no person shall be convicted of an offense under this section if the conduct that forms the subject matter of the charge serves the public good and does not extend beyond what serves the public good. So sometimes a nude photo of somebody might be newsworthy. If you have naked man attacks the Pope, that might be newsworthy. You got to show pictures or video of what's going on here. And even if that happens in private, that might be relevant. So it might serve the public good in order for those pictures to be, published in a newspaper or the like. But the end does not extend beyond what serves the public good is going to be one of those thorny and expensive legal questions. Some news organizations blocked out substantial portions of the picture. Some just didn't and relied on the cell phone that blocks the, again, key portions of the anatomy. Is it, still serving or the sort of minimal need to serve the public good if they show the whole picture versus a blacked out one? It's hard to say. They also note that for the purposes of this section, it is a question of law whether the conduct serves the public good and whether there is evidence that the conduct alleged goes beyond what serves the public good, but it is a question of fact whether the conduct does or does not extend beyond what serves the public good. And B, the motives of an accused are irrelevant. Now, the reason for the motives of the accused being irrelevant is that usually the accused is going to get up and say something like, I thought this was newsworthy and I thought this was important. But this particular section can potentially cut both ways. You could potentially have somebody who, for instance, catches a politician in some sort of illegal sexual activity, and the reason why they're publishing it is because they hate that politician. It might be that they just really despise that politician. And so that's why they're sending those photos off to a news organization. They want to hurt that politician specifically. Well, you can say, hey, motives of the accused are irrelevant here, notwithstanding the fact that they're clearly bad motives. It might still serve the public good in the case of some sort of, political figure engaged in malfeasance that the public needs to know about. There's a lot of interesting questions that come up on the reasonable expectation of privacy aspect, because one thing that gets discussed, and I had a bit of a discussion with some other lawyers and law students on Twitter over this, because this is an area that is kind of complicated. But what happens if somebody sends a picture unsolicited, but they send it to one person expecting that person not to share it further. So this would be the dick pic scenario. What happens if that person sent it to somebody and, the person who got it didn't want it? They didn't, they weren't somebody who had solicited this. They weren't somebody who was happy to receive it. And they conclude that it was an unsolicited dick pic, but that the sender was actually trying to send to somebody who did want it and had requested it. These are the sorts of questions the court may end up having to sort out later, because this is a very new area of law. There's a whole lot of case law on the idea of a reasonable expectation of privacy, but I'm not sure how applicable a lot of that case law is going to be. The reason why I say that is that most of that case law actually deals with it in the context of charter rights, in the context of searches. So if police are digging through your business, did you have a reasonable expectation of privacy with respect to the stuff they're digging through? Your car trunk. Do you have a reasonable expectation of privacy with respect to that car trunk? What if your car trunk is actually made of glass, and so the officer can just see right through? Do you have still a reasonable expectation of privacy? These kinds of questions. But it seems to me that these kinds of analysis don't really translate well when we start talking about the intimate images category. It seems like the expectation of privacy with respect to intimate images is going to lend itself to some very different kinds of analysis, because we tend to put very high weight on those in terms of, if somebody peeks through the room or the window into my office, I'm much less upset by that than if I find out they've been recording me naked or engaged in some sort of sexual activity. That would be, much more concerning. So it's going to be interesting to see how the courts sort this out. In terms of, is it an offense to share these images? Right now, I can say I don't know. And because I don't know, I'm not including one in this video, notwithstanding the fact that I suspect there's probably a defense. This is just an interesting area, and I thought I'd sort of share a little bit of thoughts here. It's unclear. It's kind of a funny case. I would be interested to see if they're going to pursue it any further, but I strongly suspect that this one is not going to make it to a courthouse, because I don't think anybody wants this particular political snafu. Anyway, that's just some fun thoughts on this one. Again, he says that, that this was a mistake changing as a sort of jogging accident. My understanding is that nobody really is pressing the issue further. And so this is just going to be one of those kind of interesting blips. It's not a story like we've seen with some other situations where somebody was engaged in some sort of, active sexual activity or anything like that. Apparently he was just nude on the camera. Anyway, thank you for watching. I hope you found this to be interesting. I think this is kind of an interesting developing area of law, and it raises some interesting potential legal questions going forward. So this was a great excuse to talk about it. I want to thank my Patreon supporters at the $50 level: Sir Daniel Wicks of Alberta, Jason Elliott, Canada's National Firearms Association, North Central Process Service, Kyle Martin, Jean-Guy Toussaint, CCFR, BCAMF.org, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited. And at the $20 level, Mark Whittington, Dale Nesbitt, Cameron Johnson, Andrew Elsich, Adam Meester, and Marc-Olivier Damour, as well as a number of you at the $10 level who will be in the crawl immediately following. Thank you for watching, and I hope this has armed you with knowledge.